Assalamualaikum, nama saya Alessia binti Nurisham, nama majlis LP2106. I would like to present the abstract. In National Land Code 1964 S 526 was announced about strata title. Issues related to strata title in Malaysia are related to strata ownership issue, joint management body (JMB) and issue and erosional issue. We have using two methodology to case. First, we use the library method and internet resources to give this case. Next is introduction. Strata data can be defined as data issue unique for spread individual and development share their common facility. Examples such as housings, apartments, and office. Strata unit owners have a share in either ownership. Strata data are required to apply on behalf of the developer. Under the Strata Data Act 1985 is established for the Management Corporation (MC), while under the Strata Management Act 2020 is established for the Joint Management Body (JMB).
Hi everyone, now I will be talking about the first case, which is between Sheikh Azman bin Sheikh Muhammad versus Lian Seng Construction Co. and Sendirian Berhad. Originally, the two parties have made an agreement on buying a third floor of a five-story building in March 1971. But up until the building is complete, the plaintiffs still have not received the strata title of the property. The plaintiff then sought a summary for a judgment in the High Court under Rule 81 of the High Court 1980. The issue here is whether the defendants are enjoined by law to procure the said strata title to the plaintiff and upon the issuance of the said strata title, to transfer the same to the plaintiff. It was originally stipulated in the Clause 6b of the agreement that the vendor shall take all the necessary steps to obtain the approval for subdivision of the said property. The court then allowed the plaintiff application and ordered the defendants to apply for subdivision of the building within 1 month from the date of this order. In conclusion, it is the developer's obligation to apply and obtain the strata title on behalf of the purchaser.
The defendant intended to construct 11 apartment buildings named Garden City Apartment on a plot of land in Malacca that he is the registered owner of. In order to buy a unit in the complex, the plaintiff joined into different purchase and sale agreement with the defendant. Section 2.04 of the agreement states that the defendant will file an application for strata title to the individual parcel as required by the Strata Title Act of 1985. The clause also states that the defendant only required to submit an application for the strata title after the apartment finished. The plaintiff unit were part of Phase 1A of the Garden City apartment, which is finished in 1990. However, the defendant still does not have the strata title 5 years after Phase 1A was finished. There are three issues for this case. First is either Section 2.04 of the Agreement Article 2 can be legal and enforceable. Second is either the defendant filed a request along with the time range specified by the Act for strata title and what were the consequences if they were unable to do so. Third is the relief were legible to plaintiff as the outcome of the defendant failure to file application for strata title within the period prescribed by the Act. There are four court decisions in this case. First is the trial judge ruled that it is mandatory for the developer to apply for strata title within the period of time mentioned in Section 8 of the Act. Paragraph 2.04 of the Sale and Purchase Agreement, which gives so much time to the developer until the whole project is perfect, is the opposite to the Act and trying to enter into a contract out of the Act. Nevertheless, Paragraph 2.04 is invalid and impossible to enforce. Second is, the court determined that on April 24, 1990, the plaintiff already received the Certificate of Eligibility to Occupy, Certificate of Fitness for Occupation. As a result, the trial judge stated once more that the defendant should have taken urgent action to apply for strata ownership to the all apartment buyers. Considering the existence of caveat, the trial judge said that under paragraph 5.02 of the agreement, the defendant can easily apply to have the caveat cancelled. That is, the defendant is liable for the plaintiff loss as a consequence of their failure. Fourth is the plaintiff claim have been accepted.
Assalamualaikum and hi, my name is Nur Hafizah binti Hassan. Today I would like to present about case 3. This case about Muhammad Nazri bin Muhammad v GMB Menara Wajah Wali and Annor 2019. This case all about the condominium and retail business owner dislike the GMB executives GMC's excess maintenance cost for stacking a retail resident and parking space. GMC's scam cheap parking. Okay. The respondents sue the first and the second in High Court for differing partial class share per unit price resolution nullifiers. Okay, the next is a fact of the case. The GMC decided that the maintenance fee for the apartments and shop would be 2 ringgit 18 sen per share unit, and that the fee for the parking space would be 1 ringgit 98 sen per share unit. Okay, the last one is court decision. For the High Court decision is under SMA 2013 rejected the first summons. The GMB or GMC may charge Strata project unit different fee if the AMG permit under SMA 2013. Then this case we carry out to Court of Appeal, and the Court Appeal decision, the Court of Appeal ordered the GMB to charge one maintenance cost for all parcel type and allocated share unit. And case is carried out to federal court, and the federal court dismissed appeal. After the court appeal denied appeal, GMBs cannot charge mid development plot for maintenance. So the respondent get the right to sue GMC and GMB to make sure them charge one maintenance fee only for two type, for residential and parking space.
Hi, my name is Muhammad Iqmal. My metric number AP210437. So, I will continue the presentation with the case Lee Wai Kin v. Yulet Sdn Bhd 1985. Fact of this case is plaintiff purchased a flat in a block of building developed by defendants. He had paid the purchase price and went into occupation, so that strata title to flat had not been issued to the plaintiff, but defendant had been demanding various sum of money from the plaintiff for expense to incur for applying for such title. Next, for the court decision, plaintiff applied to court to determine several questions. In view of Section 8.1 in Strata Title Act, it was incumbent upon defendant as proprietor of land to apply for strata title to the flats on behalf of the plaintiff. So, the court made a decision. Plaintiff need to pay the cost. Amount is the prescribed fee to be paid under Section 10(1)(a). That's all from me. I will pass to the next presenter.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Aisyah Sanadi binti Abdul Aziz. My metric number is AP210358. Another strata title case is Elvin Leong, Y. Kwan and Oz and versus Menteri Kesejahteraan Bandar Perumahan and Kerajaan Tempatan and Oz 2020 6 CLJ 55. Was ruled by Justice Kwek Chesun. In this instance, Justice Q. Chesun ruled that the judgment made by Elvin Leong should be sustained and determined that the matter brought before the federal court by Eng Min Lee and Oz should be dismissed. Facts: the plaintiff has filed a lawsuit against the defendant, who is project's developer and the seller. The lawsuit is related to the plaintiff's purchase of several condominium units in a development known as Fulton Perdana Lakeside Residence at Metropolitan Park. Between August 8, 2013 and March 19, 2014, the buyers execute their sales and purchase agreement (SPA). Each SPA is a statutory contract of sale that is defined in Schedule H of the Housing Development Regulation 11(3) HDR 1989. Accordingly, in accordance with Clause 25 and 27 of the SPA, the plaintiff shall be entitled to obtain liquidated asset damage (LED) in the event that the defendant fails to sit vacant controls of the units within the required length of time, which under the statutory contract, the stipulated time is 36 months from the SPA date. In the instance of the plaintiff, the defendants amended the length of time stated in SPA to 42 months after the individual SPAs were signed without the plaintiff's knowledge or agreement. The adjustment was made to the SPA. However, the defendants claim that they have asked for and be granted the spread extension of time (EOT), which has scratched the period for transfer of vacant possession of the units from 36 months to 48 months. According to the defendant, the House Controller sent out the EOT in letter issue 2nd July 2013 and 30 September 2015. These letters include the EOT. The defendant also claimed that the unit purchasers, including the plaintiff, received the EOTs in July 2013 and February 2016. The plaintiff claimed that they were not given the opportunity to argue before the controller owns the EOT were granted and that the release of vacant possession was late because it was outside the 36 months limit. For the decision, the Land High Court judge concluded that this case did not provide a clear and distinct example of summary dismissal proceedings in which the plaintiff motion to withdraw was rejected, and the Land Judge of the High Court reiterated the following ruling. The High Court ruled in Emily that Regulation 11(3) of HDR 1989, which grants the controller the authority to issue such EOT, is outside the scope of the law. Since the Land High Court judge is required to uphold the precedent set by Emily, the EOT issued by the controller in this instance will be declared null and void. In addition to upholding the Elvillian decision, it is ruled that the Emily decision also has retrospective effect and may be used by the plaintiff in their claim for the LED, since the High Court in Emily did not provide any clear guidance on the issue of prospective application. With regards to the res judicata problem, it has been decided that res judicata does not apply, and even if it did, the Land High Court judge has decided against applying it here, since doing so will produce an unfair outcome. Last, for takeaway, the court's confirmation of Elvillion and Emily will be heavily relied upon in any LED buyer-developer disputes, because the court is following Emily ruling that the EOTs is unconstitutional and invalid. This may increase the number of cases against developer. Since another High Court ruling confirmed that Emily had a retroactive impact, any EOT delivered by the controller to the developer would be unlawful. That's all from me. Thank you.
So first is between Syed Azman bin Syed Muhammad Berselia CKL Construction Senayan Berhad 1992 to MDL 842. This case due to Strata Property Rights. The final result of the case is the plaintiff has to apply, while the defendant must apply to for the body in 1 month started from the date of this order. Next, case law 2, which is between Sokowan and for RRS versus Lala Sediramhat. In this case, due to Strata taken, the further result of the case is the plaintiff has the right to the claim, where the defendant must apply this case to the Court of Appeal. Next, case law 2, which is between Muhammad Nazir Muhammad versus the Amir Munawar Rajawali and Anoy 2019. In this case, due to Joint Management Body JMB, the final result of the case was rejected for application in Federal Court session after the case belonged to the High Court and Court of Appeal. Next, case law 4, which is between Lee Wai-Kim versus Yuli Sriramhat 1986. This case due to originated suit issue. The final result of the case is duty or responsible to apply for strata title with the developer and not the buyer. And lastly, Tesla 5 is between Ko Chiang Hai R and ORS versus PH Relative Sinamha 2021. This case due to sale and parcel agreement SPS. The final result of the case uh, the final result of the case was rejected by the final result of the case is the plaintiff motion to withdraw will rejected by the learning high court judges. And in conclusion, the strata union, the owner who has across to the limited in your property, we have to pay maintenance charge and contribute to the cycling fund of the sub amps the sub. And thank you for fun. Thank you. That's all and thank you.